The fourth department, hear ye. All persons have been before this court will draw their good evidence and shall be heard. Thank you. Please be seated. The first case on for argument today is case 281, People versus Kamel Davis.
We're gonna call 286. Okay.
Oh, and we're also calling 286 with 281.
Thank you, Your Honor.
Thank you.
May it please the court, Bridget Fields on behalf of Mr. Davis. I only intend to argue regarding the gang assault case. It's Mr. Davis pled guilty. Thereafter, his counsel, he moved to withdraw his plea based on the fact that counsel had advised him that he could be found guilty after trial of attempted gang assault in the second degree. He moved to withdraw his plea based on the fact that he had received under People de la Cruz incorrect advice from counsel. We would,
He could plead to that charge, but it was not an appropriate conviction after trial. Is your position?
Correct. I don't dispute that it would be proper to enter a plea. My argument is that his plea wasn't knowing and voluntary because his counsel advised him that he could have been found guilty after trial. So he didn't understand what the potential outcomes could have been were he to go to trial.
I think we have that argument, counsel.
Thank you.
Thank you.
Good morning, Your Honors. Michael Tantillo for the respondent. The crux of the defense argument, according to the defense brief, is that the trial counsel for the defendant was constitutionally ineffective because of the advice counsel just referred to here. That is the sole error ascribed to defense counsel. And there are many cases that say where an allegation is that the defense attorney made just one single error, that that issue has to be so clear-cut and dispositive that no reasonably competent attorney would have failed to pick up on it. Yet in this case, counsel relied upon a decision from the first department, but the second, third, and fourth departments had all issued decisions in the past upholding convictions for attempted gang assault in the second degree.
I'm not so sure we upheld it, or whether or not we didn't reach it, whether or not it wasn't teed up properly before us.
I'm not aware of any of those cases in which the specific issue was confronted head on, but I would note that in one case from the second department, People versus Lundy, there a defendant was convicted of gang assault in the second degree, and the second department on its own motion modified the conviction to attempted gang assault in the second degree. And this court in People versus Courier upheld a conviction for attempted gang assault in the second degree, and the court's language said that the evidence was legally sufficient and the proof was the verdict was not against the weight of the evidence. Even if one were to assume that de la Cruz is controlling and appropriately decided, it is still incumbent upon the defendant to establish, and I believe the standard is to a reasonable probability under People versus McDonald, that he would not have pled guilty but for counsel's advice. Defendant furnished an affidavit in this case. He said nothing about whether he would have pled guilty or not pled guilty based on that advice. So I think under People versus McDonald and People versus Yates, which I cited in my brief, he has fallen far short of even being able to make that showing.
Thank you, counsel.
Thank you.
Case 282, People versus Miller. Counsel, please approach. I want to take this opportunity to remind everybody in the audience, and when you come forward to argue, to make sure that while you're sitting and when you come forward, that your masks are fully covering your nose and your mouth. If they are not, and if you're sitting back there without the mask up all the way, you're going to be asked to leave and you will not get a chance to argue. Fair warning. Please proceed, counsel.
Good morning, Your Honor. Mark Davison for Dakota Miller. I'd start off with the issue of prosecutorial misconduct. there are 5 different types of misconduct that are argued in the brief. The people concede it was improper to demean the defendant's case, but call that and the other instances of misconduct isolated and fleeting. I'd submit that at some point, all these instances become pervasive to the point where preservation isn't required. I'd focus on 2 of the arguments specifically. The first one was the bolstering by Investigator Hagedorn of Lewis Baker's testimony. I mean, it's one thing to say we took the guy out to dinner after we finished interrogating him, but it's another thing to say we believed him, and there doesn't seem to be any other purpose for calling this witness other than to bolster Lewis Baker's testimony. The second point I'd like to focus on is calling Mr. Miller a liar. The people point out that they never actually used the word liar, but I submit that it's worse to tell the jury that Mr. Miller told 8 different lies, and the only way to find him not guilty is to believe that he wouldn't lie to you. That it's almost challenging the jury to find that he's a liar. The evidentiary errors by the court, it's hard to characterize them. It seems like the court had its own idea of how it was going to try the case, starting with limiting the questioning of jurors, keeping 2 jurors that both sides agreed shouldn't be on the panel. But in particular, the note taking, both attorneys agreed that this was a good case for note taking. And the judge said, well, I get distracted when I
Yeah,
take
but counsel, that is more of a discretionary issue. And I think there's probably the least egregious or least, and probably the weakest argument they have. But I do agree that some of these questioning and the approach the DA took is trouble.
The only other issue I'd like to address is the ineffective assistance of counsel. I submit that this was that it was a single error to agree to let in the entire interview for the purpose of establishing that Mr. Miller was on parole. The defense could have established that Mr. Miller was not with children by himself at any time without having to make it so inflammatory that as to point out,
There was no strategy that could have explained that? Is that what you're arguing?
there was a strategy, but it was an unreasonable strategy. The strategy was misguided.
The strategy was, look, he wasn't allowed to be alone with the children, so therefore Lewis was always there.
Mm-hmm.
And therefore, by demonstrating that, he wasn't going to be alone with the child. It could have been him to do this.
Yes,
that doesn't sound like an unreasonable strategy. But is your argument that even if that was the strategy, there was a way to get that information before this jury without making reference to the fact that he wasn't allowed to be around children?
Yes, not that it was, he didn't have to focus that it was a condition of parole. It was just that he wasn't with the children alone at any point.
Very good. Thank you, Counsel.
Morning, Your Honors. John Tunnings for the respondent. I would like to start with the claim of the prosecutorial misconduct issue, and specifically the bolstering business with respect to Investigator Hagedorn. The gratuitous comments by the investigator were not responsive. This was not the prosecutor seeking to elicit the opinion of the investigator that he believed Lewis Baker. In fact,
didn't the prosecutor refer to it 2 or 3 times during summation? perhaps you'll be like Hagedorn and you can't take this Mr. Lewis out to lunch or like the police did.
Well, I
I mean,
don't,
that isn't something that seems out of line.
without question, the prosecutor, his point was, and as he expressed it, was that your review of the evidence will lead you to the same conclusion the investigators led. Excuse me, the investigators reached themselves.
You can't take them to lunch, but you come to the same conclusion that the police did.
There's no question that that's essentially the message of the prosecutor. Yes. That was not elicited, of course, by the prosecutor, and the court's instructions indicating that the comments of the counsel during summations and otherwise were simply that and may not be used as the basis for any fact finding.
That wasn't the most egregious thing that I thought the prosecutor did in her summation. I thought when he commented that the defendant cut short the interview with the police after 45 minutes when the question got tough, but compared that to the mother and Lewis that lasted for hours until they answered every question. And then Lewis was taken out to dinner. I thought that was an inappropriate comment by the prosecutor also.
I understand the court's concerns.
You do recognize that you shouldn't be commenting on him cutting off questioning and not answering.
Clearly,
questions.
a defendant's right to invoke his right to remain silent is sacrosanct and should not be the basis for a negative inference. The other claims having to do with misconduct, people acknowledge that the reference to questions as ridiculous or absurd was simply inappropriate. But that kind of comment was itself isolated. There were not additional comments regarding the defense.
Counsel, what about the shifting of the burden when we're dealing with the fact that he didn't tell anybody, changed the story with a 45-minute hour time frame? What about the argument on shifting of the burden?
It is our position that there was no shifting of the burden argument. Clearly, there was no claim that the defendant had some obligation to come forward with information. Having chosen to do that, however, it seems to me it was fair for the prosecutor to point out the various statements made by the defendant, and the defendant acknowledged in his testimony that he had lied. So referring to, in summation, referring to the fact that the defendant admitted that he had lied was an appropriate observation, and asking the jury to consider that when they determine whether or not in his trial testimony, he all of a sudden came up with the additional hour where essentially it amounted to an alibi, now claiming that he was outside for that additional hour, in contrast to what he had said at various times, including to the police.
But the prosecutor's statement again in summation that the only way to find the defendant not guilty is to believe he would not lie to you. That isn't a true rendition of the law, is it?
Oh, certainly it was not a rendition of the law. It was.
It wasn't the only way the jury could find him not guilty. They could find that you didn't prove your case.
Without question. I certainly didn't view that, and I don't believe the remark was made to indicate that this was a legal position. Clearly, the court was going to instruct the jury with respect to the legal principles to be applied to the case, but rather an argument to a collection of individuals that, listen, you have evidence that this person has told a variety of versions of his conduct, And today, recognizing that one of his original versions was more problematic, he comes up with yet a different one. It seems to me was a legitimate observation to advance to this jury in order to seek that they find the defendant guilty of having viciously killed this 17-month-old child.
Counselor, here's my issue. I find the totality of the prosecutor's conduct here inappropriate. I have to be quite honest with you. And I struggle with that, and I struggle with the issue of preservation, because we have very little, if any, preservation on any of these issues. And that's the legal conundrum that I find myself in right now, with the conduct coupled with the lack of preservation. So how does that not roll into ineffective assistance? Assuming that's the case.
I believe the legal paradigm within which ineffective assistance is determined is the answer to the court's question, which is the overall view whether or not this defendant received meaningful representation. As pointed out, the defense counsel accomplished the suppression of statements, of bite mark evidence, made cogent arguments.
Along those lines, would you address the argument relative to, was it a reasonable strategy to allow the jury to hear that he is a condition of probation, he wasn't allowed to be around children? I mean, this is a credibility case.
Well, seems to me the position of the appellant is not that it was improper for the jury to hear that he was not permitted to be around children, but rather that he was on parole. Clearly, the defense understood the defendant was going to testify. And given the Sandoval ruling, the jury was going to find out that he had been convicted of a felony and was in prison and on parole as a consequence. In addition, during the defendant's testimony, of course, he testified about having been in prison. This whole weightlifting in prison business was a function of the defendant's testimony. But no question from the prosecutor required the defendant to refer to the prison aspect of his weightlifting. It simply was gratuitous on the part of the defendant. So the point there is that believing that it was inevitable that the jury was going to know the criminal history, there was little, if any, downside to agreeing that the portion of the video, and by the way, the entire video was not.
Counsel, you have to keep that up. If you can't keep your mask above your, yes, thank you. It keeps dropping below during the argument.
I understand. Trying my best, John.
Yes, let's make sure you get it done.
The inevitability that the jury would understand this defendant's history provided essentially a safe haven for the defense to say the whole thing, the portion of the video that until the defendant invoked his right to counsel would be admitted was a no harm, no foul situation. There was no value added for the prosecution, given the realities of this trial, to have that reference included in the video.
All right, thank you. Case 283, People versus Barron. Proceed, counsel.
If it please the court,
As most of you know, the Graham case resolved two of the issues, and my additional case citation and your participation in that case. The difference here is that Mr. Barron did ask the court through his attorney's one sentence to withdraw his guilty plea. And his
But the
attorney's,
attorney didn't give any basis or reason for it, and the court didn't cut the attorney off. I looked at the cases that you cite in your brief, People versus Ramos. And there the judge specifically precluded the defendant who stated the basis for it. He wanted to appeal based on issues about the waiver of appeal. So he told the court what he wanted to do. In People versus Days, which is also the Fourth Department 2015, there the defendant wrote the letter to the court before sentencing, stating several grounds, and tried repeatedly during sentencing to get those grounds in front of the court. Here, there were no attempts by defense counsel or the defendant to state why they wanted to withdraw the plea. Just said, my client would like to, and then they moved on. And it's the court's job to ask why and go into detail.
I believe particularly in this situation, yes. The attorney said there is a request by my client to withdraw his guilty plea. The court did not ask for a basis either from counsel or the defendant. And the problem with a request like this is it could be the attorney's performance. So an attorney can't say, well, he's complaining about me. And I believe Ramos also submitted an affidavit. Those allegations were before the court. The court was aware of exactly what was at issue in both those cases, yet didn't do a further inquiry. Here, there was none whatsoever. And in a courtroom, I don't believe a 19-year-old believes that he can interrupt the court and start talking about why he wants to withdraw his guilty plea.
Counsel, doesn't this become academic if cases remitted for termination by the court?
If it's
If it's remitted for resentencing to determine why, correct?
but that would affect the sentencing aspect of it. I'm
just curious. I'm just saying, it seemed to me that you go back, and while you're back, you make an application to withdraw your plea prior to sentencing.
The defendant might still want to withdraw his guilty plea on the grounds that he wasn't truly guilty of this crime. And this court can easily, because it is going back, send this issue back as well. I mean, if there were a
No,
factual.
you missed the point, and I could be lost. It just seems to me academic in the sense, when you go back to be determined why it's part of the sentencing. Could you not make the application at that point prior to the pronouncement of the YO, a motion to withdraw your plea, because sentencing is not complete. It has to be before sentencing is complete. Now, I may have the timeline mixed up, but it seems to me that could be a potential remedy that if we don't have a proper record before us, that would have it second time around, we would.
And the only concern would be a court receiving a case back on remittal exclusively would say, well, you raised that issue and they didn't tell me to give you an opportunity. And then we're doing this again a year and a half later.
Fair enough.
So, but I do believe in this case, because of the way this plea was entered, the whole circumstance of this, that this was a case in particular, the contingency plea, his incredible reluctance to plead guilty. If there were a factual colloquy or even a DA's placing on the record that he was truly guilty as an accomplice, if this had been an Alford plea, a judge should not have accepted it because there was not strong evidence of guilt presented in that colloquy by the DA. There was nothing except he was driving a car from which someone shot. So I think that makes it even more critical that either the court vacate his guilty plea on its own or remit for the court below to hear his arguments. So this court then has a record to decide upon.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Lisa Gray for the People. Just setting aside remittal for a moment, just going back to what Justice Niemoyer mentioned, Mr. Barron was represented by a very seasoned attorney who made the motion to the court. It's not the it's not the court's responsibility then to draw out facts and circumstances surrounding this motion to withdraw his plea. The district attorney opposed it and it was denied.
And there's no challenge here about the plea colloquy being sufficient.
No. And at this point, it's well settled that this was a lesser included offense that Mr. Barron was pleading to. There does not need to be a factual basis to the colloquy. The DA laid out the events surrounding the homicide. And so Mr. Barron was convicted acting as an accomplice. I mean, he was the person who drove the car that facilitated the shooting that resulted in the death of Mr. Huntley. With respect to your question, Justice Sentra, if I would ask that this court, not substitute its own judgment and in turn remit this to county court for an adjudication determination on the record regarding youthful offender adjudication. And it would be for that sole purpose only. I don't believe it would be a proper remedy then for Mr. Barron to also seek to withdraw his plea upon remittal. So I would ask the court to.
But the sentence hadn't been pronounced yet. He certainly could ask the court to consider.
He could ask the court to consider it, yes, but it's my position that
We
would.
would hope give reasons for why he's asking the court to consider it, and the court could review those reasons.
I don't believe, though, that the court's
not precluded. They haven't. If we vacate the sentence and send it back on the ground, then the court has to pronounce sentence, and before that's done, he can ask, and the court has to consider whether it's appropriate.
Yes, Your Honor. Yes, I would agree with that. Unless there are any other questions, I would ask that these issues be held in abeyance and this matter be remitted.
Very good. Thank you, Counsel.
Thank you.
Case 284, People versus Francis.
Good morning, Your Honors.
Proceed, Counsel.
Caitlin Connolly for Daquan Francis. Your Honors, an issue in this case is the admission of evidence that Mr. Francis was found in possession of a federally controlled substance, pentylone, after his arrest for the gun crime and while he was being transported in the patrol car. The admission of the pentylone as res gestae was erroneous because the gun crime charged in the indictment was completed when the officer found the gun in the leaves and arrested Mr. Francis. Nothing regarding his transportation in the police vehicle and the white powder was relevant to the gun crime or necessary to complete the narrative. Thus,
I thought he was also charged with the marijuana that they found in the second search in the back of the car. And the reason they did the second search was because they saw the 20 vials and the white powder in the backseat.
That's correct, Your Honor, but the jury didn't, it's my position that the jury didn't need the background information of the white powder and vials in order to understand why officers might search a person incident to arrest.
So your argument is the degree of testimony is what was the problem?
In part, yes, Your Honor, there were 3 officers who testified, the chemists, there were pictures, another picture on summation. And it wasn't relevant and it was highly prejudicial, especially given the fact that the proof wasn't overwhelming. As I point out in the weight of the evidence point, the gun was found outdoors in a pile of.
Let me just stop you right there. I recognize your argument. I think the strength of what I'm looking at your argument is maybe the testimony regarding the packaging with intent to sell type of argument. But once again, the police officer doesn't normally pull a car over in the middle of the transport to pull somebody out of the back to check them and finds the marijuana. I can understand the testimony coming in to establish why he did what he did and how he found the marijuana, I think in the sock or ankle or whatever. But it would seem to me that the testimony regarding the packaging like thereof and for sale purposes on a drug that's not illegal, I can understand the argument there.
Yes, Your Honor, and I guess my point is that Mr. Francis didn't contest that he had the marijuana in his possession and didn't contest the validity of the search. So I really it doesn't seem that the jury needed to hear all this, especially the information about the sale, in order to understand why he was searched and the marijuana was recovered.
Well, you had a bit of a unique circumstance here because the defense theory was that the jury shouldn't believe that he went and put the gun in the pile of leaves, because if he had had that gun, wouldn't he have also dumped the drugs that he had on him? It just didn't make sense that he would get rid of one and not the other. So there's sort of a unique defense theory here that I imagine is why it was unpreserved and why these things weren't objected to.
Your Honor, I'd argue that, that the record doesn't support that trial counsel was strategic in handling this. If you look at the record, Your Honors, you see that his objections to the Pentalone were inconsistent. One objection was sustained, and then he didn't renew the objection when another officer gave the same testimony. Additionally, as I point out in the reply brief and then the main brief, he could have had the same strategy with the marijuana. He could have said, well, if he was trying to get rid of the gun, why didn't he try to get rid of the marijuana? It doesn't seem that the counsel's strategy was narrowly tailored in this area. And I just again point out that the weight was far from overwhelming. The gun was found in a leaf pile. There was no forensic evidence linking the gun to Mr. Francis. No one saw him with a gun or any object that looked like a gun. Unless the court has any questions.
No questions, counsel. Thank you.
Thank you.
Good morning. Just with respect to the evidence regarding the Pentalone, it is a little difficult to talk about that issue without also discussing the ineffective assistance of counsel claim. Justice Winslow, you pointed out essentially that was the rational strategy that the defense counsel used in this case. So the record to me was very clear that counsel was allowing some measure of this evidence regarding the Pentalone. That exactly that, if he's going to discard a gun, then why would he have these 25 vials?
Put in packaging and intent to sell.
So regarding the intent to sell, I think this court should look at that under a harmless error analysis. So if you take out that testimony regarding the intent to sell, you still have overwhelming evidence regarding the observations of the police officers, the gait that Mr. Francis was using walking towards the leaf pile, how he looked when he was walking away from the leaf pile. I think there was a lot of testimony, actually very specific observations regarding Mr. Francis's reaching, his shoulder movement, things of that nature. It was very close in time and proximity to the leaf pile when the gun was discovered. Obviously, counsel's strategy, wasn't successful, but it was a reasonable one. It was a rational one. And even eliminating that intent to sell, just taking that little piece of testimony out of the trial, still the weight of this verdict is still supported by overwhelming evidence. I would ask that this court apply, a harmless error analysis with respect to maybe the intent to sell evidence. But regarding the Pentalone itself and the observations, that certainly goes to trial counsel's strategy with respect to this defense. Unless there are other questions, I would rest on.
Thank you, counsel.
Thank you.
Case 285, People versus Young.
Good morning.
Proceed, counsel.
Good morning, John Sarando on behalf of the defendant, appellant. This is an appeal from a conviction for the crime of predatory sexual abuse against the child following a guilty plea. The defendant was sentenced to 14 to life. I think when you look at the guilty plea, and especially in this case, it has to tailor the plea proceedings to the defendant's situation. This defendant, counsel indicated his time and place becomes significantly separated or separated significantly. He's got a traumatic brain injury, PTSD. They tried to plead guilty in November and he didn't recall anything. They then come back in April and the court was counsel worked hard to get you to plead. You should have pled before. I'll be vague on the facts. You just have to say yes. The court really pushed for a plea. The defendant
But
finally.
during that plea colloquy, didn't both counsel and the defendant, they answered, perhaps the defendant answered yes to penis and anus contact or mouth vagina contact. They specifically denied penis to vagina contact.
Yes.
So it seemed that they were acknowledging the contact.
Yes. And I think then after he pled guilty, I think this is a basket case for the new value of the new discovery situation before you plead guilty. Because after this fragile individual pled guilty, he was then given a result of a test that indicated his DNA was not in the bedding involved. The alleged victim had an STD, which he didn't have. And he also indicated that he wasn't in the area of that time. And he wrote he wrote numerous letters to the court. And at sentencing, he says, I didn't do it. The evidence actually supports my claim that I didn't get till after I pled guilty. I admit to something I didn't do because I was afraid. The court made no inquiry whatsoever, none at all. And all he did was say, well, I'll consider, if you want me to consider your letters as a motion, that motion is denied. There should have been some inquiry by the trial court, especially when the defendant receives exculpatory evidence after he pled guilty. I think when you look at the totality of circumstances and considering this defendant's background insofar as the voluntariness of a statement is concerned, I think when you look at what we've delineated in our brief as to some of the
So let me
psychological.
understand the voluntariness of the statement. You're talking about the interview with Detective Ferry, right?
Yes,
And in viewing that video of that interview, your argument is not that Detective Ferry did something wrong during that interview. You're saying we need to take a look at the defendant's background and state of mind and how he reacted to what appeared to be a very appropriate, methodical questioning by Detective Ferry.
I say the psychological pressure invoked on this fragile minded defendant, who, when he comes into the room, is told, you'll get help if you disclose everything. And once you've done so, you can go home. And that was a total lie.
We'll take a look at his background and what you're talking about is how he was raised, the information we have in the record with respect to his grandmother's treatment of him when he was with his grandmother. These are the things you're talking about, his experience in the military.
In the military.
All of those things combined, you say, left him in a fragile condition.
And the fact that he had what was it, his space and time, was
That was articulated during the
inappropriate.
conflict, right?
Not only that, and I think when you look at the way we've laid it out in our brief compared to I think it's the word would be the vanilla way with it, the trial court listed the facts of the quote voluntariness of the statement. I think you've got more inquiry, and hopefully this court will see through the way the individual was treated. Insofar as
We'll take a look at that, Mr. Sarando. Anything else?
just one thing, Your Honor. I think the sentence should be modified if not the plea vacated or the matter go back to determine if the plea should be withdrawn. I think telling the defendant that he should rot in hell, I don't think is appropriate for any judge to say. And
Yeah, but without condoning the language of the sentencing judge at that time, the language you're referencing, the range though was closer towards the minimum, right? It was a minimum 10.
minimum 10, yes,
Yeah, and he received 14,
right.
right?
Right.
Okay.
Of course, he would have gotten 10, I think, if he pled in November to the other charge. And he was just indicted because he wasn't able to allocute at that time due to his mental condition, things like that. So we submit that when you consider his upbringing and the way he was treated and everything, that 10 years would be appropriate.
Thank you. Counsel.
Thank you.
Morning, Your Honor. Brad Osler for the people. May it please the court. I would disagree with my opponent's belief that there is really anything in the record that suggests that the defendant was in such a fragile state that either the court was obligated to sort of conduct some sort of further inquiry, order a 7:30 exam. I think those issues are somewhat closely tied. I mean, the reluctance to plead guilty, I think, is much more related to the fact that, as it would be difficult for anyone to admit, painful facts and then understand that you're agreeing to a certain sentence. I think it was 15 years. It was the people's second offer that he sort of attempted to accept initially. And I think that's also what the court was indicating, that counsel had worked hard to get a favorable disposition for him, or at least as favorable as he could. Not that he'd worked hard to convince him to plead guilty as much as he had just simply worked hard to get something on the table that might have been something that the defendant may have.
Well, we do have here, the crime charged is very serious. But we also have here a defendant who has a very sympathetic background that's been put forth before us in the record. We also have a defendant who, through this interview, ultimately cooperates. He has no criminal record. Isn't this the kind of defendant that ought to be getting the low range of the sentence?
I wouldn't disagree with that, Your Honor. I think he served in the military. It looks like the discharge he got was, not to besmirch him, it was not an honorable discharge, but I don't think it was because of any sort of misconduct on his part. I think it might have been conceivably because of the mental health.
Yeah.
And certainly the lack of criminal history speaks well for him. So I don't disagree that a sentence on the lower end of the range is certainly appropriate. The court went in that direction, as you pointed out a second ago, Your Honor. But I think apart from sentencing concerns, which, he is a relatively sympathetic defendant despite the charge and the acts alleged. But I think on the rest of the record, I don't think the court did anything inappropriate here.
Counsel, thank you. Case 287, People versus Palmer.
May it please the court, Adam Nero for Quantry Palmer. 5 points were raised in the brief. I intend to focus on the first 2 points, the Batson issue and the suppression issue. And we'll submit on the brief unless the court has questions on the other points.
Very good.
The prosecution offered 2 race-neutral reasons to defend their strike on the first Batson challenge. However, neither reason is borne out by the record. The first reason was that the prospective juror, Robinson, was a single mother. However, the record reveals that they did not strike an otherwise similar white juror, Zankel, who was on the same panel. The prosecution didn't dispute that Zankel was otherwise similar, and moreover, the court didn't make its Batson decision on that reason. Rather, it asked the prosecution to clarify its second reason. The second reason it offered was that, that Robinson required the children's testimony. However, that's not borne out by the record either.
Well, counsel, let's go back to the first. Aren't we dealing with the first issue? Wasn't there an age difference between the two prospective jurors?
The court noted that there appeared to be an age difference.
Significant age difference.
Yes, he described Zankel as a really old lady and Robinson as young.
Not sure 70s is really old.
I'm not sure either.
As I get closer.
Yes, but even if there was an age difference, which actually isn't borne by the record either, we do have the prosecution, the judges noting that there appeared to be. However, all that's on the record is that they were both mothers of adult children. So they were, even if there was an age difference, making them not the same, they were still similar in that sense. And
Yes, so and to the point of asking for the children's testimony, Robinson merely asked what the ages of the children were.
Well, no, she first asked, had they been questioned, and when the prosecutor responded that they were too young, she asked the prosecutor, tell me their ages.
Yeah, she asked for the ages, and when she found out that they were 5 and 3, she never asked any other questions after that. And also when the prosecution later asked Robinson some direct questions later during the voir dire, he never returned to the issue of whether or not she wanted to see the children's testimony. She asked about her involvement in the block club, and I believe whether or not she was ever married.
But the court found that, in their opinion, watching the demeanor of that juror and the prosecutor, that it wasn't a pretextual challenge. And isn't that given some weight by us?
When it is based on demeanor, it would be given weight, some deference. However, there's nothing on the record to explain that it was based on her demeanor. He referenced that it was that Robinson piggybacked off another prospective juror who suggested that they get the testimony of the 5-year-old. However, that was after the interaction with Robinson, and there was nothing on the record to indicate. And I think if you look at the second Batson challenge, where the prosecution did articulate that their reason was based on demeanor, that was properly laid out on the record, that it was, she seemed nervous, she seemed timid. There was no indication that, you know, for example, she nodded along when the other prospective juror suggested that they get the testimony of the 5-year-old. And so
The court did grant one Batson, correct?
yes, and that was the one that was based on demeanor. The second one where he suggested that that juror looked timid and nervous. But then the third Batson challenge, which isn't an issue here because it was for an alternate juror who didn't participate. There was also some misrepresentation of the record indicating that they contended that that juror would naturally feel sympathy for the defendant. However, the record doesn't bear that out. The prosecution asked the question several different ways, but essentially was always asking, would you naturally feel sympathy for that juror? And each time she said no. Once she actually explained that even if she did feel sympathy, she would still view the evidence on the merits. And there was another juror, a white male who did serve as an alternate, who he actually did say on the record before that concern about what happens to the children is something that naturally comes to mind. However, they didn't strike him either. So for those reasons, again, even if the misrepresentations and the inaccuracies from the record weren't intentional, they're still not borne out by the record requiring reversal.
You want to hit the suppression issue?
Yes, on the suppression issue, Ms. Palmer was in custody from the moment that the first officer placed her in the back of the patrol vehicle near the scene. She was held in the back of a locked police vehicle for over an hour before she was transported to a police station for a field sobriety test, then to a hospital for a blood draw, and then to headquarters for a police statement, all in the back of the same locked police vehicle. Any reasonable person in that position would assume that they were in custody. The fact that she wasn't arrested or handcuffed that morning doesn't negate the fact that the view would be that there was restrictions on her freedom, that she clearly couldn't just get up and leave when she pleased. And also to the statements. There's no dispute that she wasn't read her Miranda warnings at any point that morning.
Well, counsel, if we take your rendition or your theory that she was in custody, then obviously are in post without Miranda's, there's no dispute, is subject to suppression, including the blood test.
Yes.
It just appears from the record, though, this woman, this defendant was very cooperative throughout the whole time.
She was
willing to go, willing to participate, willing to go back to a police statement, willing to write a written statement. Correct? I mean, so really, we have to look at the record. If we come to that determination that you did, I think the answer is simple.
Yes, there's nothing on the record because she didn't testify at suppression hearing, but there's nothing on the record about her asking to leave or asking for an attorney. However, excuse me, the fact that she was agreeable and went along with all of the officer's requests, it was never at her suggestion. Nothing was a voluntary utterance or just a response to a benign statement. It was, come with us for the field sobriety test, do the blood draw, tell us what happened. It was never just a statement, so that would require.
We'll take a
reversal.
look at that, Council.
Thank you.
Thank you.
Morning, Your Honor. It's Michael Hillary for the people. I'll respond to the first point first, unless the court has any questions about it. The prosecutor did establish that there were race-neutral reasons for the strike of juror number 2 in the first panel. As Judge Centra pointed out, there was a difference between that juror and the allegedly similar situated juror. There was a significant age difference as perceived by the court. In addition, the allegedly similar juror was a widow, whereas the structure was a divorcee. I'm sorry, not a divorcee, but was not married and had 2 small children. So there were significant differences there that factored into the prosecution's reasons.
Counselor, I'd like you to address for me that wasn't addressed by counsel on one of these mornings. The conduct of the assistant district attorney. Court grants a Batson, and the assistant district attorney is alleging that the court called him a racist. And that banter went on the next morning, and the colloquy, and what's in the record, is disturbing. I mean, the conduct and what took place. I have to credit the court on this. I thought the court's demeanor and throughout the whole time was superb. But I don't know whether or not the assistant district attorney is trying to gain an upper advantage by putting the court in an awkward situation, not to grant another one. But address that to me. That's my interest.
Well, Judge, I think I tried to put myself in the prosecutor's position. And it's sort of an imperfect analysis, of course, because it's subjective and we're all different. We'll respond differently, perhaps. But I think a serious-minded, conscientious prosecutor, if they are on a receiving end of a Batson challenge, especially where they think there's no merit to it, it would be quite natural for the prosecutor to be upset at the
I
implications.
don't think it would be quite natural to say, Judge, I'm not sacrificial lamb because you're afraid of getting overturned. That's not the way it works. Even a conscientious professional would not be saying those words.
Sure, Judge, and I am not defending everything that was said or the manner in which it was said. I'm simply trying to understand the effect on a conscientious prosecutor who approaches his job with
We
integrity.
understand that there can be a temptation for it to be taken personally.
Mhm, mhm.
That's a temptation that needs to be overcome.
I think so, Judge. I just would point out that and due recognition to what Your Honor has just said, I don't have any quibble with that. It costs a defense attorney nothing to levy a Batson challenge against a prosecutor, whatever its merit or lack of merit. A serious-minded prosecutor who is a person of character or is trying to be approaching their job with respect and diligence, it's natural to be upset by the implications of that challenge. Again, that doesn't mean the prosecutor has carte blanche to respond however he wants. I'm not defending that.
I'm not questioning that he shouldn't be personally offended if that's the case. It's just the way he conducted himself. I wonder whether or not it's a trial tactic. Is it a move to put the court in a defensive situation so that if another Batson is made, which was made afterwards, it might have affected the ultimate second decision by the court or another decision. Because this court, I can speak for this part, has seen hundreds of Batson cases. And we've seen where the court granted it. And I've never seen one where the DA, the implication is if you grant a Batson challenge, I'm a racist. I've never seen one. I don't think, and you've heard in front of us for a number of years, I don't think you've ever seen one where you equate a granting of a Batson to being a racist.
I can't say personally I've seen the argument made by a prosecutor. I know that there are strong feelings had by prosecutors at what are considered to be, and I'm not speaking directly to this one, but for frivolous Batson challenges. Again, I am not advocating for a particular response by the prosecutor. I think he would have done well to keep his peace despite the emotions that aroused in him. I'm not sure. I think it's a very interesting discussion, and I think it's a very important discussion to have about how prosecutors respond to a Batson challenge and the nature of the implications of the challenge. But I don't know that it's particularly relevant unless you assume the prosecutor was up to some machinations behind it. And I don't think my take is it's not a fair assumption on the record. However, right or wrong.
Yeah, whether it was strategy or not, the unprofessionalism of those comments to the judge and putting the judge in that kind of situation was clear, and it shouldn't be encouraged.
I'm not going to dispute that the reaction might have been much better in the circumstances, Judge.
Very good. Proceed, counsel.
So unless the court has any questions, further questions on point one, I'll just move on to the second point.
Very good. Thank you.
So when we look at the encounter and the course of events from the arrival of the initial responding officers, Officer Petrozak, who had the initial contact, and once she was brought back to the scene of the crime, it's very clear that they were treating this as an accident investigation. In fact, Officer Petrozak, once there was some intimation by defendant that there was some altercation or some argument, stopped and said, you know what, I'm going to leave this to the accident investigation. Then Lieutenant Leatherbarrow gets involved. He notices that she's intoxicated or showing signs of intoxication. He's treating it as an accident investigation. She's completely compliant. She's cooperative all the way. They are always asking her at every step whether she would be willing to accompany them to have the field sobriety, accompany them for the blood draw, and then give a statement. The statement that she gave that was in writing, her writing, is different than that which was the concern of the Paulson court. The Paulson case was cited by counsel. In that case, the pad was put before the suspect with pen, and he was asked to write what happened after he had given some very incriminating evidence about his involvement in sexual crimes. Very different from this case here. The defendant really hadn't said anything to arouse any real suspicion of criminality when she was asked to give her statements about what happened. So I think that she was cooperative. I think that the police had a right to, an accident investigation had a right to investigate, figure out what had happened, and there was no custodial interrogation here.
Thank you, counsel.
Thank you.
Case 288 in the matter of Caden G.
Good morning, Your Honors. May it please the court. Phil Rothschild, Hiscock Legal Aid for Mr. G. An abandonment finding in this case was precluded by custodial interference. The mother moved and left no forwarding address or contact information.
What steps did your client take to see this child over the 3 years? He never went to court. And I was particularly disturbed by some of the findings of the family court judge that your client in 2019 offered to give up his parental rights if the mother would forgive his past due child support, or that your client had sent a text to the mother threatening to chop the child up and put him in a dumpster. So,
Your Honor, there's no question that Mr. G's behavior throughout was not ideal, and I understand that. But he did make efforts to see the child. But unfortunately, his avenues of contact were through the mother's mother, through the grandmother. That was it. And there was no indication.
He always has the right to go to court, though, doesn't he?
Yes, that's true, Your Honor. He does. However,
he didn't during the period of time.
he did not. He was apparently unaware. At this point, he was under an order of protection for his behavior, which was terrible. There's no question about that. But what he was under this misimpression that he could not even try to obtain custody. It was a mistake of law. He was wrong in that regard. The order of protection had been extended. He was never notified. I understand orders of protection lapse on their own, but he was never notified that the order, in fact, had been extinguished. But I would also point out that other efforts to contact, he tried contacting through the grandmother. There was nothing there. But I would point out other elements of alienation in this case. The child was told that John was the father. The alienation did not just happen with Mr. G, but it happened with his family as well, both his mother and his teenage daughter. The mother's new husband sent inappropriate texts to that teenage daughter, telling her to disown her father and threatening to cut off her contact unless she got Mr. G to sign off on his rights to Caden. And we would submit that looking in toto, that the finding of abandonment should have been precluded because of these efforts at alienation. And that leads directly into the second point, which was the lower court erred in finding that an adoption was in Caden's best interests. As I noted, the contact with paternal relatives had been curtailed or eliminated altogether. A termination of parental rights in this case would essentially make that permanent. So Caden would never know of, would never see any of his relatives. And the other point I'd like to address is that Mr. G's situation had in fact changed over the years. He'd been a truck driver for 20 years until an accident, a serious injury. He became, like many Americans, addicted to opiates. His life spiraled out of control. He lost his job. He lost his license. He's no longer able to drive a truck. But by the time of this hearing, he had basically gotten himself back where he was gainfully employed and he was earning a living. The other point,
But counsel, when we look at our measuring of that, we're looking at the 6 months, we're looking at whether or not he's a notice father, consent father. Once again, as Justice Niemeyer pointed out, there was a 3-year period of virtually one visit, virtually no child support. I mean, you've just said to us, well, he didn't understand the law. He had an order of protection. Well, what efforts did he take upon himself to pay some kind of child support, to pay for this child, to send a Christmas birthday gift, birthday card? I mean, is there anything in a record that can lead us that he made those types of efforts? Because even if he realized he got an order of protection, doesn't mean he can't pay child support.
as far as the first thing I'd like to address is as far as the context, there was no way for him to contact the child. The mother had left no forwarding address. Everything was through the grandmother. As far as the child support,
Through the grandmother, he could have sent it to the grandmother. Could you forward this on? Could have made an attempt to send a card to the grandmother. Could you please forward this on to my child? I mean, there's, what Justice Niemeyer was pointing to earlier is it not just an effect with the court. What steps did he take? I mean, okay, he didn't understand the law. He could have contacted the grandmother. Could you forward this to my child? He could have, he found a way to pay some child support, because my notes reflect that he paid virtually no child support, which leads me to believe that he had paid some. So there was a point in time where he paid some. Why didn't he pay child support?
As far as the contact, there are indications that he testified that he left messages with the grandmother, never returned. As far as the child support, he was out of work. That is not an excuse, but that is a factor to take into consideration. He had lost his job. He essentially had no money on his own. But the other point I'd like to address is how he had changed his life. He was basically suffering from an undiagnosed bipolar condition, which finally, during this period of time, he finally got medication and he had improved his life. But this was another factor that the court failed to take into account when determining what was in the best interest of this child going forward, to basically be separated from his.
But that's, I recognize, that's assuming we get the best interest.
Yes, Your Honor. But I would submit that many of these things, they're interrelated. And I would ask this court to take a look at this, also to take a look at the relative, basically Mr. G clearly had done bad deeds, but I would point out that the mother's new husband was not Simon Pure as well. He had a violent history, which I would submit was even greater than Mr. G's. And his improper texts and comments to Caden's sister were in fact something that the court essentially dismissed and should not have. I would ask this court to take a look at these matters.
We'll take a look at that, counsel. Thank you.
Thank you.
Morning, Rebecca Cons on behalf of the respondent. In this case, there were multiple ways that this father could have tried to contact the child. He was represented by counsel throughout the proceedings, so he could have reached out to the counsel. He knew where the grandmother lived, as was evidenced by his going and trying to break down the door. So he could have reached out to the grandmother in the 3-year period. He said he tried 2 or 3 times. He could have filed a violation petition if she was actually actively denying him contact, which it's not clear that she actually was. And as far as the support under the statute, it's not just contact. There were other ways that he could have shown that he didn't
And the
intend.
court did find that he offered to give up his parental rights if she would forego the arrearages.
Yes. And he did minimal child support, but even if he had, done very little, but had maintained that, it would have shown that he at least wanted to. He could have proven that he was sending letters and the letters were returned. There was none of that in this record, that he was making attempts. And he didn't
The
make
court said
any.
that there were no attempts to hinder, did they?
Right. The mother did invite the daughter, his other child, to birthday parties. She was trying to get them together to meet up at the fair. So the mother was, when she had seen the paternal grandmother, she said, that she could see him, but the paternal grandmother never followed through. So there were ways that he could have shown that he still wanted to maintain contact with his child, and he didn't. And until the adoption petition was filed, he wasn't taking any action. It wasn't until if the adoption petition hadn't gone forward, chances are we would have just kept continuing on with no contact. It wasn't until that he was like, then he wanted to say that, oh, this is my child.
And I take it you believe the court had a substantial basis in the record?
I do. I think that the court was in a good position to be able to determine the credibility of the testimony and the witnesses, and I think they found the right decision. Unless there are any other questions.
Thank you, counsel.
Thank you.
Case 289 Weldon versus McMahon. Proceed, counsel.
May it please the court. One of the pitfalls of deciding a motion on grounds that were never raised is that we don't have a full record. The trial court didn't have a full record. If this had been an issue that was raised, they would have found out that no more than 8 days after I filed my original answer, I was having email exchanges and telephone calls with Stephanie Vaselli about permissive use. And it would have been, and it was certainly known at that time that permissive use was an issue. This was a mistake. I checked the wrong box. I put it in the wrong place. In fact, I believe it was Stephanie Vaselli that told me that, hey, you know what? You don't even have, you admitted it. Oh, great. I'll get on that right away.
Well, you have a situation here, you filed a motion, counselor put an answer in, she doesn't raise this issue. And the court in one paragraph, one line, person just mentions the prejudice at the end, and that's the end of it.
Right. And in this particular case, there are many witnesses out there that may or may not, I believe they're going to corroborate my story, but there's nothing here. The plaintiff didn't even argue prejudice. They just argued something about insurance, and that may be for the policy limits, but under 388, my client is on the hook for anything above that, and under the court's decision, they're on the hook for that. And my malpractice is on the hook for that, anything above that. So, this was a simple mistake. I certainly have a meritorious cause. I have an affidavit from somebody that was there and actually handled this thing. The opposing brief cites cases that we're talking, 2 years after a summons or an answer was filed, 3 years after. In one case, there was a first trial had already been conducted.
Well, and Kevin Wilson is a really interesting one because I'm pretty sure he's running out of leverage.
Technology has not been fine-tuned completely, folks.
All right, well, I'm hearing counter arguments right now.
Yeah, no, that was not just in our heads. That actually happened. So
there's no spoliation here. It's unfortunate that Allison.
One of the difficulties of this case, though, is the timing of this. I mean, plaintiff's counsel had plaintiff's counsel received the answer that said that permissive use was being challenged, right? At that time, there was still time say between 7/20/20 and 9/15/20, where counsel could have taken steps to maybe send an investigator out, done some work to get that statement done before the person regretfully passed away.
Well-
And so I understand the argument, and Justice Sentra, of course, is completely right. I don't think prejudice was argued, but it seems to me that there was prejudice here potentially.
Well, here's a couple of issues that add into that. One is that the plaintiff didn't file this summons and complaint till 2 years and 11 and a half months after the accident. All right. They were on notice that, again, because we weren't allowed to brief this issue that came up just in the answer. I would have been able to submit the emails that I had with plaintiff's counsel a week after my answer that clearly would have shown it was a mistake in my answer.
And that really, the crux of your argument is, the record is insufficient at this point. If we're sitting here with a full record, we can then make a determination whether or not it's an abuse of discretion or lack of abuse of discretion. But without a full record, without an opportunity to be heard, you were denied that. And it was a course that was charted by plaintiff's counsel by not raising it when you filed your
Right, and they're in no different situation now than they would have originally, because Allison Argy died the day after she was allegedly served. So,
Well, but again, as my point was earlier, there was a period of time, a couple of months before her death, that had counsel been aware that there's a challenge to permissive use, there could have been steps taken to lock down that, send an investigator out, lock down that testimony, find out if it was or wasn't permissive use. You know,
I
who's to
understand.
say whether plaintiff's counsel would have done that, but there was an opportunity there. So they are in a different position once Argy dies, right?
I don't believe they are because the timing here is so close to when she was actually served. And I will tell you, as I said, the reason that Ms. Vaselli and I were having that conversation is because she said she couldn't find Allison Argy, and she asked me if I could accept service. And again, if we had a full record, you'd see in that email that was in
Counsel, are
July.
you saying you had discussions with plaintiff's counsel shortly after the answer was served?
8
saying
days.
That it was a mistake?
8 days. It would have been clear at that. Again, I didn't notice the mistake at that time, unfortunately. But she was on notice that because I even said the permissive use issue, issues that are out of this, that arise out of this accident are from a law school exam.
So within 8 days of serving the answer, plaintiff's counsel was aware that there was a mistake?
Yes, absolutely. And unfortunately, that's not in the record because we were never allowed to even brief that. So.
Thank you, counsel.
Thank you.
Morning, Your Honors. May it please the court. Jamie Richards on behalf of respondent. Obviously, I'm not Ms. Vaselli, who is scheduled to be here today. I was discussing emails there, but the standard of review here is abuse of discretion, very high standard. There is nothing in the record to indicate that Honorable Judge Carolinus abused her discretion in reviewing the record and the facts presented to her. As such, we would.
In other words, if we were individual trial judges and maybe we would have decided the case differently, that's really not the standard. The standard is, did the trial judge in this case abuse their discretion in making the order that they made?
Correct. And it's my understanding that judge had all of the facts presented by both parties and came to the conclusion that the motion to amend the answer should be denied 7 months after it was initially filed.
Thank you, counsel. Anything further?
No, thank you.
Case 290, Williams versus Henry. Counsel, please proceed.
Well, I'm the AFC, is the appellant. The appellant said he was going to participate.
I have,
remotely.
yes, I have Anthony Bellatieri Jr.
That's me.
scheduled to appear, and that's it.
That's it. Oh, okay. I'm sorry. Yes. Good morning, Your Honors. Anthony Bellatier Jr. appearing as AFC. This case involves a petition for modification of a custody order
that was filed by my client's mother. The previous order had mandated that supervised visitation with the children. It also ordered that after 6 months, she would be able to file a modification petition. And also mandated that she attend.
There was no dispute about the fact that that 6 months had lapsed and that under the court's previous order, she qualified to file the petition, correct?
Absolutely. I'm not disputing that.
Right.
She did. She also complied with the requirement to attend counseling. She did those things. She had standing to file a petition. However, I'm arguing that that does not relieve her of her burden of proof to demonstrate that there was a substantial change of circumstances that necessitated a modification of the order in the children's best interest.
Well, the court, interestingly enough, the court in this case had put forward a very detailed order with respect to visitation to try and get the parties to work together, and admitted, I think, kind of the court threw up their hands saying, my efforts did not work.
Yes.
And would that by itself be enough to change the circumstances to allow for the court to redress?
I'm arguing that it did not, Your Honor. And I'm aware that the factual findings of the court that had the opportunity to examine the demeanor and the credibility of the witnesses is entitled to great deference, but I'm not really asking this court to disturb any of her factual findings. Rather, what I'm arguing is that the court's order is not logically and internally consistent with the findings of the court. The court, if you read the decision in order, the court specifically found that although the mother had complied with the supervised visitation requirement and the counseling requirement, that she really had not benefited or learned anything from those services and continued to exhibit the same problematic behavior that she did before. And yet the court proceeded to modify the order in a graduated step-by-step process leading to eventual overnight unsupervised visits. And I'm arguing that that was not in the children's best interest. And
The court's plan was to gradually, very gradually, it seemed to me, increase the level of visitation to the point where I think it was September of 2021, there were going to be weekend overnights, if I'm not mistaken. And so that has all transpired.
That's correct. That all happened. Well, if what's going on now is more litigation in family court. I've kept track with there's a different AFC representing the children in the Oneida County Family Court.
Mm-hmm.
I've kept track with the children and with that other lawyer. And currently, there's another petition filed, and the overnight visitation has been temporarily suspended. So it happened for a very short time. Apparently, there are problems. The family court is still reviewing that, but has not issued a decision. Apparently, there was 1 day of a hearing in late February, and it's been adjourned until June, unfortunately. So that is still being litigated, and I am asking this court to weigh in on that and hopefully provide direction.
Very good.
Okay.
Thank you, counsel.
Thank you, Your Honor.
Case 291, Ontario Inc. versus Goodrich Aerospace Canada Ltd. Counsel, proceed.
Good morning, Your Honors. May it please the court. The lower court got it wrong, and the lower court got it wrong because it did not follow this court's ruling in Simpson and Simpson v. Lippis Mathias and New Kayak Pool Corp v. Kevin O'Kane Cook. The collective teaching of those cases is that there is a proposition that a successive motion for summary judgment may be made when it is substantively valid and will serve the ends of justice and cut through some of the issues that can be dispensed with to focus the jury's attention on what matters, which is the ultimate purpose of summary judgment in the first place. Here, there was a reasonable justification why the appellant did.
Let me just stop you for a second. So a motion can be made early on in the case before discovery, a dispositive motion. And then you're saying that counsel reserves the right after discovery to go forward with another dispositive motion and the court has no discretion within which to grant that motion?
No, Your Honor, that's not what I'm saying. I'm saying the court does have discretion whether to grant it or not grant it. Here, I'm saying the circumstances were such that the court should have exercised its discretion to hear the substantive motion on the merits.
And why is that?
Because at the time that the first motion was made, thousands of documents had been produced in discovery. Because the crux of the first three elements of a common law fraud cause of action necessarily rest on evidence that are exclusively within the respondent's mind and their possession. When we got possession of documents produced in discovery, which were presumed authentic pursuant to 4540-A of the CPLR, we thought we had it.
But so you brought the motion before you did depositions to find out what those documents really meant. And then what you're saying now is that is your choice to bring the motion, your choice to bring it before depositions were had to figure out what those documents really said. And then subsequently, when you lost the motion and then you did depositions, now you're saying, well, we have new information. But that information was available to you prior to your first motion.
Well, our case, Your Honor, is a little bit unique because we're not saying that we didn't understand what the documents meant. What the circumstance is.
You're saying that their later statements contradicted what the documents say.
Their own documents.
Yes.
So we could not and should not have to anticipate that the respondents were going to disavow their own contemporaneous statements that they never thought would see the light of day.
Well, all they did was explain away what those documents meant.
Well, they contradicted their own statements, correct?
How you want to call it, they did. And you had the opportunity to depose them prior to bringing your motion to confirm that. It's just you shortcutted this, but what I'm saying is at the end of the day, you appeared, one of the elements is establishing whether or not the information was available to you. That's why it's called new evidence, new discovery, but it was available to you. You just never utilized the method to get it prior to bringing a motion. That's the way I look at it.
Correct, Your Honor. So we absolutely, Justice Sentra, you're correct. The appellant could have made a motion for summary judgment or conducted depositions prior to the making of the first motion. 100% correct. However, you cannot, the appellant in this case, upon receipt of the documents produced in discovery, thought that it had the clear and convincing proof that it needed. So in attempting to shortcut and cut through a lot of the issues that came up on the more than 10 depositions that were conducted in the 1,000 pages of deposition transcripts, which ultimately, if we get to the second prong of our appeal, which is that the motion for summary judgment should have been heard on the merits, that the deposition testimony that came out of those witnesses supported the appellant's interpretation and what those original documents.
Again, before you even get there, it's within the discretion of the trial court to decide whether or not to let you renew, and they use that discretion in any way.
Your Honor, it's the appellant's position that the trial judge did abuse his discretion and should have granted the motion.
Exactly how you think that.
Because in this case, it's not as if there's a contractual provision like in the Centerline case where it could be subject to different interpretations. Here, we were dealing with the respondent's own words, their own statements. And
but again, as has been pointed out, you could have taken those depositions before you made the original motion.
we could have, Your Honor, yes. So what the appellant is saying is that we could not anticipate that the respondents were going to disavow their own statements. So once the trial court, which was affirmed by this court, denied the first summary judgment motion, we went back.
Counsel, so what you're saying is it was a reasonable trial strategy. It would have saved a lot of time and effort on behalf of the client relative to depositions and discovery, because once you received those documents, you thought on the face of those documents, you had enough to bring the motion at that time. And you did. And that's a reasonable approach to this litigation. And you're saying to us it's unreasonable for the judge and an abuse of discretion because the judge in this instance is not factoring in what we could not have known. And that is when we got to the deposition, they would be changing their story and that we couldn't take the documents on their face. And that's an abuse of discretion when the judge does not allow us a second chance on the motion. That you were simply trying to save the court and save the parties litigation expenses. And that's a reasonable approach. Is that what you're arguing?
That's correct, Your Honor. So Goodrich Aerospace Canada and its parent enjoy revenue, which is stated in the record of $50 billion. We were trying to limit the issues in the case, and instead of doing 10 depositions with thousands of pages of transcripts, we could have only done a couple of witnesses with substantially less deposition, which would in turn cut down on the trial time. So that's the crux of why we are arguing that Judge Walker abused his discretion in not hearing the substantive motion on the merits. So the three main points that came out of the deposition testimony, which undercut the opposition that the respondents raised in opposition to the first summary judgment motion, was that this passport process was on paper, but in reality, it could be accelerated at any time. Goodrich could pull the plug on TwoSource whenever it wanted to, that the decision to end a supplier's relationship with Goodrich would not be made until parts were transferred to a new supplier. And the deposition testimony of Ms. Tracy Franz proved that in January 2016, so approximately 12 months before the current contract ended, the parts were in fact moved. So those are all factual admissions that would have changed the prior determination of the first motion.
Okay,
And
so we have to look at it and see whether there is an abuse of discretion. That's the bottom line.
Okay, thank you, Your Honor. That's my argument.
Thank you, Counsel.
Good morning, Phil Golisano for the respondent. I think simply counsel made an error, a strategic error in moving for summary judgment early, and it didn't pan out. And now they want a second bite at the apple. There's absolutely no reason here to give that to them. There's zero justification.
Well, there may be reasons to allow this to happen that are very reasonable reasons, but what I think I'm struggling with is, you know, different judges may view this case different ways. And some judges may grant the renewal. Some judges may not. But the fact that you're ruling one way or the other, does that mean it's an abuse of discretion if you don't go one way or the other? That's where I am on this case.
And I would submit, Judge, it is not abuse of discretion at all. And the ironic thing, Your Honor, is that prior to making this motion, they had already served deposition notices. They knew the identity of every single one of these witnesses that they now seek to rely on to claim new evidence. They could have very easily deposed these.
Well, they're not arguing that they didn't know who the folks were. And so that's to be expected that they knew who these folks were. They're simply saying that they wanted to save some costs of litigation, which is, I don't think, an unreasonable approach to make. But I think what you're saying is it was a gamble.
Sure, and I would also address the cost. You could always move for summary judgment right off the bat and argue it's always going to save cost. I don't think
But
that's.
again, I think probably that the issue is, as Justice Whalen just pointed out, that maybe as a trial judge, somebody could make a different decision, but wasn't an abuse of discretion. And that's
Certainly, and our argument is it is not. With respect to the whether or not this is even frankly new evidence, again, we would submit it's not. If you look at their brief, they're really not relying on any deposition testimony. All they're really doing is regurgitating the same emails that they had in the first motion for summary judgment, the first appeal before this court. And on the record with those emails, the same emails that are now before us, this court found that the plaintiff did not meet its burden. And there's no new evidence here. It's just cumulative.
So your argument is twofold. If there's no new evidence, the court lacks the authority to grant such a motion. And if there was new evidence, whether or not there's an abuse of discretion standard that needs to be utilized.
That's correct. And with respect with the underlying merits of the case, which I don't think this court should get to, there's no new evidence. The court has already considered all this evidence, all these emails, found there's questions of fact, and there's no reason to change that based on this record. Thank you.
Thank you. Case 293, the Walton and Willett Stone Block LLC. versus City of Oswego Community Development Office. Proceed, counsel.
Good morning. Camelot did not change its position as a result of anything that the plaintiffs did or didn't.
Counsel,
do.
how do we even get to Camelot? Don't we first have to find that you have a cause of action against the city before we get to Camelot? Specific performance, you have no contract with Camelot.
That's correct, Your Honor.
So if the city was appropriate in canceling your contract for the purchase of this property, then there can be no claim for specific performance against Camelot.
True. So the city claims that the financing contingency was not met, and the financing contingency benefited the plaintiffs, not the city.
But
And
that was a
didn't need it.
determination of the court below about why you don't have a contract with the city. They said your client doesn't have a contract with the city because there were two buyers, and only one of them is your client. And therefore, the city was appropriate in canceling the purchase of contract.
That's correct. In the initial action, and then the new action that the Fowler Gardella did add in as plaintiffs. They were the other party to the joint venture.
But the court below found Fowler was not ready, willing, and able to close on the date specified.
In the initial action you're talking about, yes.
So I don't understand in specific performance. You draw the unfortunate panel of the two of us that were in dissent on the last technical issue, but saying that you weren't going to get specific performance because of latches. I don't even understand why we get beyond you didn't have a contract with the city.
I understand. I can't change the facts, Your Honor, and I rest on my brief with respect to that point.
Very good. You want to move on to another point, or?
Unless there's questions, I don't have any other points.
Very good. Thank you,
Thank you.
counsel.
Morning, Your Honors. John Devendorf for the City of Oswego. I'll likewise rely on the brief and the reasoned decision of the court below because I agree with Your Honor that the contract was properly terminated and there is no longer any remedy.
Thank you, counsel.
My name is Anthony DiMartino on behalf of Camelot. I'll rely on my brief as well.
Thank you, counsel.
Thank you, Your Honor.
Case 294, Davis versus Evangelical Lutheran Church.
Good morning, may it please the court.
Proceed, counsel.
It's our position that the trial court was in error in denying our motion to dismiss on the basis of the evidence that was presented in support of our motion. Specifically, a brief chronology of the events is significant and dispositive. The alleged abuse was claimed to have occurred in 1975 and 1976. The synod did not exist in any form until 1987. So therefore, they could not have hired, supervised, retained the alleged abuser because they simply did not exist. Further, the Church of the Ascension did not.
Let me ask you this.
Yes.
With respect to that point, part of what we have to do is take a look at the documentary evidence and see if it's sufficient to
Right.
establish what you just said.
Yes.
Okay, very good. You say it is, your opponent says it isn't.
Well, our opponent is relying on a deed from 1998, I believe, which transferred the property of the disbanded church to the synod, which occurred by operation of New York state law. Religious Corporation Law, Article 2, Section 17C provides that if there is a discontinuance of a congregation, the property transfers by operation of law to the synod, which is what in fact occurred. Now, the legislature could have stated that any obligations or liabilities are transferred along with the property, and they did not do so. So there is no independent evidence to establish that the synod voluntarily assumed any liabilities, and the evidence that was presented clearly establishes they did not exist at the time of the alleged abuse.
Very good. Proceed.
So if there's no further questions, I'll rely on my brief.
Thank you, Counsel.
Thank you.
Morning, Your Honors. May it please the court, my name is Cheryl Kennedy for the plaintiff. So the issue posed here is whether the synod defendant is liable for the torts alleged, and also whether the synod defendant has established their defense that it was not in existence at the time complained of. Now, upon the documents within the record and the documents submitted by the synod defendant, of course, the documents prove that the synod defendant was in existence at some point. I believe the certificate of incorporation was from 1987, and that it was affiliated with the Ascension at some point. However, the plaintiff submits that these documents do not establish a defense as a matter of law because they leave unanswered the exact timing of the creation or the formation of the synod defendant and whether it was established as an entity for the purpose of overseeing the church. So we submit that the certificate of incorporation references a previously incorporated synod, or it references the synod as an unincorporated entity for purposes of incorporating same. The yearbook submitted also do establish that the synod defendant was affiliated with the Ascension at some point, and that the synod defendant did exist, but they do not establish exactly when that point was. So we do submit that, the documents don't establish a defense as a matter of law. They don't specifically establish they did not exist during the time of the abuse complained of.
Thank you, Counsel.
And if there are no further questions, I'll rest.
Very good. Thank you. Case 295 and 296, Bardsley versus Great Lakes Industrial Development, LLC.
May it please the court, Jean Final for the plaintiffs. This is a case of a de novo review of a denial of a class action claim. And it's contrary to kind of how it was phrased in the statement of facts of defense. It's actually a plastic recycling plant that has thousands of pounds, thousands and thousands of pounds of plastic chips. And a small fire turned into a disaster because of the negligence of the defendants is the claim of the plaintiff. And the whole purpose of a class action is to open the door to people for litigation that they couldn't otherwise do. And here, that's why it's so important to have a class action in this case. There's thousands of people that were affected. That's in the state records, that's in every other place. There's thousands of people. Each person, the proof needed both on negligence and more fundamentally on proximate cause relating negligence to the injuries goes with all of them. It's not.
Is that true, counsel?
Yes.
Because my understanding of proximate cause of relation to injuries, if I'm claiming liver cancer or skin cancer, the proximate cause is going to be entirely different for each and every individual. Isn't that true?
The injury is unique in some cases because there's 5 classes of plastics that were released and those cause various injuries. But the thing is that to show proximate cause in a chemical case, you have to show the chemical was there. You have to show it was there in sufficient quantities to cause the injury, that kind of chemical causes that kind of injury. And
But
that
in this case, there's a number of different injuries.
right,
isn't there?
because there's a number of different chemicals, but there's 5 classes of plastics. The thing is that those aren't the treating doctors. All those factors going through, they aren't treating doctors. They're scientists and other doctors that specialize in that environmental thing. That's the main crux of it. The treating doctors are the least of it. The main proof, which is unique to all the injured parties, as well as proof relating to the property damage, those are all the same, that what kinds of plastics are those? What do those plastics do? Mr. MD.
Counsel, we deal with the commonality.
Yeah, the commonality.
The 5 factors. We're talking about medical. We're talking about the the injuries to each individual. So you have multiple individuals with multiple different injuries with some with pre-existing.
Right.
How does that fit into that compartment?
Well, the thing is that there's five, like I said, five groups of plastics, and those cause specific kinds of injuries. And they are cancers and different other things, and respiratory and neurological and stuff. But they all have that kind of chemicals cause those kinds of injuries. So it would be the same, if that were the class of it, there would never be a class action involving injuries, because there's always people have different injuries and come to it. We take the plaintiff as they find it. But the primary part of it is that the fact that this person had that kind of injury, and that kind of injury is directly related there, affects the other guy who had that kind of injury. So that
That kind of injury. So
Like
if we were dealing with, everybody had respiratory injuries caused by the inhalation of a certain type of plastic. And you were proving that that type of plastic through scientific evidence causes that respiratory disease. But we're not just claiming one injury. There's a respiratory disease, there's a kidney disease, there's heart disease. Each one of those would require a different type of scientific proof.
Well, they all require the same type of scientific proof, but maybe a different things, because it's about what things does benzene exposure cause. There's a certain number of chemicals that were found by the state that were there, as well as like soot and particulate matter. Those cause a number of kinds of injuries. And it's that the fact that those cause it, it's a plastic factory that got out of control because of like gross negligence, really, on the part of the defendants, that would always cause a whole variety of injuries to people, including respiratory, including neurological, including cancers. So that those cause that. And it's the same kinds of scientists that would talk about all of those for all the cases. The proximate cause, that John's injuries relate to Jane's injuries, relate onto the proximate cause. Those are proof of it. That to have them separate is that, it's just total injustice to the people. That's the one aspect. The other aspect is without class certification, the overwhelming thing isn't just commonality. It isn't a class action, just isn't about whether it's to have a joint trial or separate trial. It's about opening the doors of justice to people. You have a person with probably $100,000 worth of disbursements. They're supposed to bring their case. And these aren't people who have nothing to lose. These are people who have houses, tidy houses, modest houses. They have something to lose. They can't afford individual cases where they have a risk of exposure unless it's divided. These people divided the 75 agreed to
That's
have that.
the reason there's a liberal construction to
Yes.
Article 9. I understand
Yes.
that. But you do admit that under Article 9, there's 5 factors, and you need all 5.
And you need all 5. And the commonality is overwhelmingly the proximate cause issue. Their individual, how their cancer is going to play out in their life is really a small part of compared to proximately causing that cancer to the chemicals in this fire that were exposed and the length of time they were exposed. That's the main days of trial will be on that aspect. So to separate that out and to have each person have to have separate, or to have each person that had to decide, are they going to be part of a class or not? Because of that, they won't have any rights if there's not. The factors are on both sides of the equation. It's not just on the plaintiff side. Both sides are to determine whether or not the factors of 901 and 902 are a factor. One thing I wanted to point out on 902.1 is whether or not individual people are interested in being able to be the ones to shoulder the burden. Okay, that's 902.1. So the fact that we sent out to a number of people, whole boxes came back of ones that didn't get there for whatever reason. But the fact that we sent those out, that shows these are the people. Most people aren't willing to shoulder. They aren't willing because what they have to lose isn't from their excess. Like maybe you or I could afford to lose from our excess. These are people who what they will lose is from their need. That's why that it's a limited group that's willing to represent the class and willing to be responsible for that type of issue. So it's really they're typical claims in the sense it's more than one claim, but they are typical claims because those kinds of chemicals and those 5 classes of plastic, those types of
Counsel,
chemicals.
I think we have that argument.
Yeah, yes.
I think we
Okay,
have that.
thank you, Judge.
Thank you.
Thank you.
Good morning. May it please the court. Megan Brown on behalf of Industrial Materials Recycling LLC, one of the tenants in the warehouse where the fire occurred. this is not a case that's appropriate for class certification, particularly for the reasons raised by Justice Nemoyer and Justice Sentra. The issues and addressing commonality first, it's the questions that predominate, whether the questions that predominate are common or not. And here, the ones that predominate are clearly unique to all of the various plaintiffs because of proximate cause. The type of proof you would need to prove aggravation of lupus versus COPD or something is certainly going to be different types of experts. And it has nothing to do with just an expert talking about what injuries can be caused by a class of plastics, but whether that class of plastic actually caused the injury to that specific person. And based on the number of plaintiffs and injuries alleged, the questions that predominate are clearly unique. And so for that reason, Judge Walker got it correct when he found that there was no commonality. Additionally, the numerosity requirement is not met. Based on the efforts of plaintiffs' counsel, the members of the class have been identified, they're finite, they're known, and the class is not so numerous that joinder is impractical because joinder has occurred. We have the plaintiffs between the Bardsley action and the Torres action, they're all known. The doors of justice are open to them, and the actions have been joined for purposes of discovery and trial and liability. So all the cost is shared. There's not going to be 75 different trials. There'll be a liability trial, period. And then damages, period. So there's no, numerosity is not satisfied. And so for those reasons, superiority is not satisfied. There's no reason to have a class action here where the members of the class are identified. And so we don't even need to get to the factors of 902, CPLR 902, but I would submit those also support affirming both orders.
Thank you, counsel.
Thank you.
Honorable Justices of the Appellate Division, my name is Zach Kosinski. I represent defendant responding Great Lakes Industrial Development LLC. We'll largely rest on our papers and the arguments advanced by the other defendant on this appeal that were just made. If I could just briefly make a couple of points. Appellant argued here that this appeal is subject to a de novo review, but as the Court of Appeals has noted, whether its lawsuit qualifies as a class action matter is a determination made upon a review of the statutory criteria as applied to the facts presented, and it ordinarily rests with the sound discretion of the trial court. Therefore, it's subject to an abuse of discretion standard, and we would submit that the lower court did not abuse its discretion in this case. Plaintiff appellant also advanced arguments related to the CPLR 902 factors. As we argued in our brief, appellant did not raise those factors in their opening brief, and we would submit that they were waived. And regardless, they cannot satisfy them here. Unless the court has any further questions, we would rest on our brief.
No questions, counsel. Thank you.
Thank you.
Yep, goodbye to you. 97, the Pasquale Condominium Board of Managers versus 1094 Group LLC, and Justice Whalen is recused on this matter.
Good morning. May it please the court, Elizabeth Pringle for Concept Construction Corp.
I'm sorry, can you keep your voice up?
I will work on that, Judge.
Thank you.
All right. In as much as these are two appeals argued together, I'm going to take them in order, 297 and then 298 with the issues that pertain to concept construction. So on 297, the lower court should have granted dismissal of the entire complaint. The lower court properly granted dismissal of plaintiff's causes of action for negligence and unjust enrichment as against concept, but erred when it did not dismiss the breach of contract cause of action. That breach of contract cause of action arises from a settlement agreement between the parties that was executed in 2015. That related to a lawsuit that started in 2014, which was premised on the alleged defects of the window systems at the Pasquale condominium, which was completed in 2009. So with respect to the breach of contract cause of action, plaintiffs failed to allege what specific terms of the settlement agreement Concept allegedly breached. The complaint broadly claims that the windows weren't fixed as a result of the settlement agreement. I think everyone concedes that there are still issues with the windows. However, what Concept agreed to do under the settlement agreement was to perform work pursuant to the reports and design specifications from the Ellicott defendant consultant, Peter Mueller. These are referred to throughout the papers as the Mueller reports. Mueller reports were referenced as it being attached to Exhibit A of the settlement agreement. They do not, however, appear to be provided with the settlement agreement that was annexed to plaintiff's complaint, and they are nowhere in the record. So plaintiffs have not, under their current complaint, identified which specific provisions of the settlement agreement Concept allegedly breached. So we submit that the breach of contract cause of action should have been dismissed, and therefore the entirety of the complaint should have been dismissed as against Concept. In the event that the entirety of the complaint is not dismissed and remains on the vine, so to speak, turning to the issues in 298. In that event, Concept should be able to proceed with its cross-claim against the Ellicott defendants. The Ellicott defendants were a party to the settlement agreement. Their consultant furnished them with the report, the Mueller reports.
But all the EDC had to do was pay them, right?
Oh, Your Honor, we disagree with that. We believe that's where the trial court erred. The obligations of the Ellicott defendants under the settlement agreement expanded beyond just the mere payment of money. Because they furnished the Mueller reports under which the repair work was to take place, they impliedly warranted that those design specifications and plans were accurate for their intended use and suitable to fix the issues with the windows.
But they had no duty to supervise any of this work or perform any of the work, correct? So I guess I'm kind of missing the point.
Sure. So under the Spearn Doctrine, a party who provides design plans and specifications for a project impliedly warrants that those plans and specifications are suitable, accurate for their intended use. So when a contractor comes in and takes those design plans and specifications and performs the work according to them, if there is any failure, for example, in the Spearn case itself, the contractor there performed pursuant to design plans and specifications, and the sewer failed and the dry dock
That's the
flooded.
crux of your implied warranty. They told you what they thought was wrong, what should be fixed. You claim you followed that, and evidently, if you did it wrong, it's because of what you received from Mueller.
Correct. Exactly. So the whole crux of the cross-claim as against the Ellicott defendants arises from that implied warranty that they're the ones who furnished the design plans and specifications for the repair work. And then lastly, the last point I would make is with respect to the alleged warranty disclaimer, the Ellicott defendants make an argument that there was a provision in the contract, and I'll quote, this is from page 56 of the record, that there are no representations or warranties other than those expressly set forth herein. Case law establishes that that's insufficient to suffice as a disclaimer of the implied warranty under the Spearn Doctrine. It's simply too broad and does not give sufficient detail or notice for that particular implied warranty to be disclaimed. I'll rest on my papers unless there are other questions.
Thank you.
Thank you.
Good morning. May it please the court. My name is Aaron Knights, and I represent the defendant R.E. Krug Corporation in this matter. R.E. Krug Corp is a subcontractor of Concept on this project. So our arguments align principally with precisely what Ms. Krangle just ably argued. So I don't want to belabor the points that she made, all of which apply to my client as well. I would like to point out in response to Justice Smith's question about this, the settlement contract, that Paragraphs 1.1 and 1.2 of the settlement agreement provide that the EDC defendants will solely agree upon the labor that is done by both Concept and Krug. So that goes beyond just making payments. And then, you know, the record is pretty replete with facts that were put in that show that they actually took upon themselves the role of supervising the work on a daily basis, changing plans after modifying some of the plans after the work had started, approving the project, being updated on the project throughout the repair work. So I'm happy to address any questions that the court may have. Again, I don't want to repeat. I have a whole long outline here, but I don't want to. I don't want to keep everyone from getting lunch here when my points have been made pretty strongly in the papers and by Mr. Crandall.
Thank you.
Thank you. Thank you for your time and attention.
May it please the court. Good morning, Your Honors. Michael Curley. I represent the plaintiff in this matter. Let me just give you a little context. Three of you are not from the city of Buffalo. This is a building that was built on the waterfront.
Yeah, we're really aware
Okay,
about that.
so bottom line is that by the time they finished the project to remediate the windows, more window systems had failed after the remediation than before. That was the result of a number of different things. To begin with, you needed a building that didn't have window systems that were working. And as a result of that, there was a meeting with the EDC defendants wherein they agreed to undertake to fix these window systems or to remediate them, which they did within the context of a settlement agreement. The underlying agreement between the plaintiffs and EDC is demonstrated in minutes of a meeting that were actually circulated and agreed to after modifications by both sides, which we put in the record. So that begins to address the first issue, which is EDC's responsibility was only to pay money. It goes far beyond that. As indicated by my colleagues, and I won't belabor the point, they undertook supervision, they conducted weekly meetings, they modified the plans while they were on the site, and they were fulfilling an underlying obligation to the plaintiff. With regard to the claims against the two contracting defendants, Concept and Krug, the complaint clearly states in paragraph 22 that an inspection of a failed window, and just so you know, it's the lower end of the building so that they didn't have to get a scaffold up, indicated that there were gaps in the insulation and in other areas of deficiencies in the window that were striking to the people that removed it. So there's a clear allegation of failure to provide an appropriate and proper sealed window system. I would like to address and move beyond that to the negligence case, the negligence claims, the unjust enrichment claims, just briefly. With respect to EDC, I would suggest to the court that if it didn't see that this was a good contract claim, it certainly is an unjust enrichment claim based upon the way EDC managed the settlement agreement based upon its underlying obligation to the Pasquale pursuant to the minutes of the meeting. With regard to Krug and Concept and EDC, it appears that during the course of these proceedings in the construction project, they went beyond various areas of the
You have
contract.
a cause of action for a contract and negligence. I mean, we have a contract and a tort.
Right.
So, if you have a contract, a breach of contract.
It's usually subsumed within the negligence.
And
That is correct.
But your application of it is different towards EDC because EDC would be a negligent tort action.
It could be independent of the settlement agreement if that was the basis of the contract, because of its underlying obligation to the Pasquale, which we would submit it did not appropriately execute. If there's no other questions, the hour is late, and I will rest on the balance of the brief.
Thank you.
Good morning, Your Honor. I'm William Bruckner with Woods Oviatt Gilman on behalf of the 1094 group and 10 Elkwood Square Corp. The Justice Walker got it right in dismissing the breach of contract claim against the EDC defendants and dismissing the complaint in its entirety. The settlement agreement that serves as the basis for this action was a carefully negotiated agreement with the assistance of counsel, and it chose very carefully to define the responsibilities of the EDC defendants in the agreement. And those responsibilities were very simple. They were to pay the Krug and Concept defendants for the work that they did in rectifying the leaky windows. And the agreement authorized EDC to choose whether to accept $125,000 apiece that Krug and Concept were contributing towards the cost of the remediation, and to determine whether that contribution would be made with labor or monetary contribution.
Well, do me a favor. Would you focus your argument on the negligence claim?
On the indemnity, Your Honor?
The negligence.
On the negligence.
The negligence.
Your Honor, there is no independent legal obligation that arises outside the context of the settlement agreement in this case. The settlement agreement explains what the obligation of the EDC defendants to Pasquale Condominium is. And beyond that duty, there is no independent duty. And so the tort claim is totally inappropriate.
Anything further?
Your Honor, I'll rest on my brief.
Thank you.
Thank you.
No, I did not.
Case 300, Goki Aronson Inc. versus Bearing Distributors Inc.
Good morning, Your Honor.
Counsel, proceed.
Ryan Cummings from Hodgson Russ on behalf of the plaintiff appellant Quickie Aronson. We're here on what is a pre-answer motion to dismiss in a battle of the forms case under the UCC. I'm sure that makes everybody excited here this morning. Here, it's governed by UCC 2-207. There really is no dispute that there was a contract between the parties. The only question really is which provision of 2-207 governs here and what are the consequences of it. As we've set forth in our brief, it doesn't really matter if we go down the 207-1 path or we go down the 207-3 path. We still end up at the same conclusion, which is that the defendant, BDI's terms and conditions, and specifically their venue provision, never became part of the contract between the parties, so the dismissal on that basis was wrong.
So you're saying the court, when they said there was a counteroffer that was accepted, that was different than your purchase offer, was wrong?
Yes, Your Honor.
Okay. And then his secondary position that somehow that was a supplementary term or based upon a course of conduct could not be possibly done on a 3211A1 motion, because how can you have a hearing if you're attempting to dismiss on purely documentary evidence?
Correct, Your Honor. So what's interesting here is the argument that was made to the trial court by defendants was 207-1 governs. And now on appeal, they're saying 207-3 governs. So there's a bit of a disconnect between the order that
And we're not even going to get to the first argument was that they were the original offerer. They've dropped that too.
That isn't part of this argument. The actual proposal expired by its own terms.
I'm just somewhat confused by the venue language. It says all transactions shall be governed by the laws of the state of Ohio, and venue shall be in Cuyahoga County. A venue of what? It doesn't say legal actions. It doesn't say proceedings that come out of this. It just says venue. And the only thing that it refers to is all transactions shall be governed by the laws of Ohio. So it's a choice of laws, except conflict of law rules, and venue shall be in Cuyahoga. It isn't clear that it means you're consenting to bring your lawsuit in Cuyahoga. Does it say that?
I don't believe it does, Your Honor. We never got to that argument before the trial court because it's so far down the analytical path on this one. If we go down the current path that they've presented here on the appeal, which is 2073, excuse me, that there is no contract. So now we're governed by just the terms of the two agreements that agree, or the exchange of documents that agree, plus the UCC gap fillers. The UCC gap fillers do not provide any type of venue clause whatsoever. So that doesn't get them to where they want to go. And with the course of dealing, they try to say that it's supplemented by the course of dealing between
The case law
parties.
is pretty clear. You can't just keep exchanging forms. And the cases that they're citing say without objection, but isn't each and every purchase offer you make an objection to any additional terms?
Yes, you end up having these conflicting objections with each exchange of documents between the parties.
So it's not that you accepted and performed without objection. You objected each and every time you put in a new purchase offer.
And I'm sure they would take the same position, that they objected to our terms and conditions each and every time they issued an invoice or an order confirmation. So we end up with that conflict. And simply on a motion to dismiss, you can't just put in an affidavit from a party to say that there's a course of dealing here.
The affidavit isn't documentary evidence.
It's not documentary evidence. Exactly, Your Honor. With regard to 2071, we've done that whole analysis in our brief. I won't reiterate it here other than to say that it starts with our purchase order. And even if we were to consider their terms to have been properly incorporated by reference and all of those various analyses, the simple fact of the matter is we've already objected to the additional terms and a venue clause as a matter of law.
So the terms that you don't agree on get dropped. And this isn't one of the supplementary terms supplied under the UCC.
Exactly, Your Honor.
I think we have your argument, counsel. Thank you.
Thank you.
Just past the afternoon, so good afternoon. Seeing as how council rested on the briefs on the issues regarding 2071, I think I'll focus on 2073 and then we can move forward with this. I think it's useful to take a step back and see kind of how the James affidavit, which is the affidavit that the court relied upon in determining that a course of dealing had been established, how it was presented and how it was referred to by the parties in the record. So in its opening brief and its motion to dismiss, the BDI specifically referenced the James affidavit that had established a course of dealing and relied upon it in arguing that this term, the modification of terms language and the terms and conditions as a whole have been incorporated by reference. That in their opening brief, very bottom of the brief in the first footnote, it said, to the extent that the court, and by extension, COICA, believed that there were any factual issues that required determination regarding the historic course of dealing, that jurisdictional discovery should be taken. COICA's response didn't object that the James affidavit was not a proper documentary evidence, didn't even cite CPLR 32.
So your contention is that an affidavit saying there's facts out there is documentary evidence?
I think, Your Honor, that if there had been an objection on that basis that this was not properly considered, that at the very least the court probably would have either converted it to a motion for summary judgment as we'd argued for alternative relief or allowed discovery. But that was sort of the
if you're going to have discovery, are you going to convert it to allow for other things to come in? Then it isn't an A17 motion, is it?
Well, Your Honor,
A1 motion.
So I think what the situation would then be is if the parties were to present documents that shouldn't be considered on an A1 motion, that the court would then convert it to a C motion, you could permit discovery, and then it could have an immediate trial on the merits of this particular issue.
But you moved under A1.
We did move under A1, and there was no objection to the documentary evidence that was submitted.
But you can't under A1 then say I want an evidentiary hearing on A1. That would defeat the whole purpose of being unrefutable or irrefutable documentary evidence if you're asking for a hearing.
Well, Your Honor, I think it would be the court converting it. If the court believed that the evidence that was submitted and objected to was outside the scope of A1, the court could then convert it to A1. to the 3211C motion. With respect to the sort of the merits of the party's course of dealing, I think it's important to recognize, as Your Honor mentioned, there were exchange of forms here, and both exchange of forms objected to the other side's terms and conditions, but in every circumstance, you have the sort of undisputed course of dealing here was COICA would make an offer, BDI would send a response. So in every single response, COICA said, we want these products on these terms. BDI would in response state, no, we won't agree to those terms and we'll only contract on this basis. And in every instance, COICA would then come back and order again. This is a 20-year course of dealing in which COICA.
Each time they sent a purchase order, they said, we're only making the offer if you accept our terms. And then you would send them your thing and saying, we're only selling you if you accept our terms. And I thought the case law is pretty clear from Judge Levine, who says that's not how UCC 207 works. If you agree on the terms, then you take the agreed terms. The disagreed terms drop out and you supply it. I don't see where it's being supplied, and certainly you're not contending that the venue is not a material issue.
No, I would agree, Your Honor, that the question of materiality is not an issue here because that's a 207-2 issue. So the only question here is whether or not under 207-3, this is a supplementary term supplied by the UCC. COICA doesn't argue in its brief that course of dealing sort of as a general matter is not a proper supplementary term. So the question is, the evidence that was submitted, did it establish a course of dealing? Putting aside the question of the admissibility of the James affidavit, we'd say that in this circumstance, there was a tacit acceptance by COICA, even though it objected to terms inconsistent with its own in its purchase orders. The fact that it continued to make offers to contract month after month, year after year, shows that there's not really a symmetry here. Because COICA, if it didn't like the objection, if it didn't like the terms that were insisted upon by BDI, it could have found other suppliers, but it didn't. It kept coming back and it kept ordering more and more for 20 years.
Very good.
Thank you, Your Honor.
Thank you, Counsel. Case 301, Shapiro versus Syracuse University. Proceed, Counsel.
May it please the court, Andrew Morrison on behalf of the defendant appellant, Syracuse University. The motion to dismiss had two prongs, 3211A5 statute of limitations and 3211A7 failure to state a claim. With respect to the 3211A5 motion for statute of limitations, it was addressed to allegations of conduct that occurred in 1982 when plaintiff Shapiro was 17 years old. With respect to the 3211A7 failure to state a claim, that was addressed to the claim sounding in negligence against Syracuse University. Excuse me. I will take the 3211A5 prong first. It is undisputed that these claims are time barred unless they are revived by the Child Victims Act, which is referred to as the CVA and which was codified by CPLR 214-G. And 214G provides that it will revive claims for civil claims for injury, quote, suffered as a result of conduct which would constitute a sexual offense as defined in Article 130 of the Penal Law, committed against the child less than 18 years of age. Those claims are revived. With respect to plaintiff Shapiro's claims in 1982, he was 17 years old. So he cannot take advantage of.
Not unless there's forcible compulsion.
Correct, Your Honor.
And they allege in their complaint, at least my reading of it, is that something along the lines that either he's used force or fear or a number of other aspects. That was alleged in the complaint, wasn't it?
Yes, Your Honor, it was alleged, paragraph 59 of the amended complaint uses the word forcibly without consent. Paragraph 61, forcibly without consent. Paragraph 62
Okay.
alleges
And
force,
under 32
fear,
and under 3211, why isn't that enough?
because those are legal conclusions, Your Honor. The use of force is a legal conclusion. And again, we are not arguing that these claims or these allegations should be subject to a heightened pleading standard under Rule 3016. We did not move under CPLR 3016. We understand that on a motion to dismiss in the normal course where 3016 doesn't apply, it's 3013. But even 3013 says that the allegations have to be sufficiently particular. Those are the words of CPLR 3013. Sufficiently particular to put a defendant on notice of the material elements of its claims. And by just alleging.
So you're saying you just can't say, use the word force or a form of the word force. You have to have some other allegation that indicates that maybe a person was held down, was stopped from leaving by being grabbed, or was intimidated to a point where they couldn't move. And without those types of factual allegations, it's insufficient.
That's absolutely correct, Your Honor. Forcible compulsion is defined under the penal law, and there are no facts to support the legal conclusion that there was force or that was intimidation. That's absolutely correct, Your Honor. And, we skipped to the allegations of forcible compulsion, but just the concept that there has to be an element of lack of consent in order to constitute a sexual offense. And the court below erred by saying it wasn't going to consider a lack of consent because it believed that 214G applied to anyone who was under 18 years of age at the time of the alleged abuse. And so we also respectfully submit that that was an error of law. With respect to the 3211A7 motion, which was failure to state a claim sounding in negligence, there are really two claims. One is negligence, and then one is this negligent hiring, which is also wraps in negligent retention, negligent supervision. And we have cited to this court, and we cited below cases like Doe versus Al-Sad and Sheila C. versus Povich, that with respect to a negligent hiring case, there has to be a prior knowledge or notice, and that has to be supported by specific facts. And again, we're not relying on 3016. These cases say that specific facts underlying prior notice, specific facts underlying prior knowledge is an essential element of the claim. It's not a pleading standard. It's an essential element of the claim. And here, the amended complaint cannot allege that Shapiro was a student at Syracuse University, that Shapiro participated in curricular activities at Syracuse University, that Shapiro was a student, lived in student housing at Syracuse University on campus. And there are no allegations that Shapiro's parents entrusted Shapiro to Syracuse University, which distinguishes the cases that are cited by plaintiffs. This is not a case where there's a 10-year-old or a 14-year-old who has to go to school, who has compulsion to be in school, and whose teachers are authority figures. And while absolutely the conduct that's alleged in this case is abhorrent, full stop, period, we're talking here about whether or not Syracuse was negligent. And where there's no allegation that Syracuse even knew that Shapiro was on campus, we respectfully submit that even on a 3211.
What if the allegation they knew because they allowed the coach to bring athletes, young athletes such as him, on campus?
Your Honor, I'm sorry, I didn't understand your question. Whether they knew because they allowed him to bring people on
He was
campus?
a coach, right? He was just the defendant was a student here. He was a graduate student, and he was a coach, correct?
I'm sorry to interrupt. The perpetrator was a graduate student at Syracuse
And
University.
he also was a coach, correct?
He is not a party. He was not a coach. No, the allegation is that he was held out as a coach.
And so maybe on a 3211A7, that's accepted as true.
So
So
he is a resident advisor, and there is claims that non-students were brought to campus for coaching. And they claims that Syracuse had received credible reports regarding the resident advisor's sexual abuse and actually observed improper touching of minors on campus. There's allegations to that.
yes, Your Honor, that's the crux of it, Your Honor, is that they have alleged that Syracuse University received quote unquote credible reports, or that Syracuse University received red flags, again, quote unquote red flags. And they even allege that Syracuse University personally, or someone at Syracuse University personally observed Mainwaring's inappropriate conduct towards minors. The problem is that concepts like red flag, concepts like credible reports, credible is absolutely a legal conclusion. What is credible? Is not backed up by any fact. And again, there's a difference, there's a big difference between not having to plead with specificity and relying on unsubstantiated allegations. And you can't just say Syracuse received red flags, Syracuse observed, or Syracuse, whatever the other term was, I flew out of my mind, red flag, credible reports. And then say, well, I'm just going to rely on the standard under 3211A7, that's all going to be accepted as true. And this court, time and time again, has held that you need more, that bare legal conclusions are not enough, and are not entitled to that type of deference on a 3211A7 motion. If there are no other further questions, I'll rest on my briefs.
Thank you, counsel.
Good afternoon, may it please the court. I'm going to present the argument respondent in opposition to Syracuse, and then at the same time, I'll appellant against Camp Greyhound.
Please do.
And I'll do that. And again, I'll take questions on both issues as I'm going along, but I will start with Syracuse. What you've heard is that basically the argument is with Syracuse is pleading deficiencies, that we didn't plead enough facts. Now, again, it's a pre-answer motion.
Counsel, I'm gonna have to ask you to keep your.
I'm sorry.
You have to keep your mask up.
Oh, I'm sorry.
No, yeah, we need to have.
Yeah, no, I didn't realize it fell, Your Honor.
All right, very good.
3211A7, I think as Justice Lemoyer pointed out, at least at consent, and Judge Center as well. We pleaded lack of consent, and I think implicit with all the sordid things that are alleged, clearly there was no consent, at least to survive a 3211A7. Now, if it's going to be summary judgment, that's fine. But again, I think what Judge McCrae was pointing out as well was the idea is that there's been no discovery. This is 40 years. This is 40 years. All the information now is being held by Syracuse of what's going on. But with respect to duty, he was a dorm advisor. He was permitted, again, students would be coming on. Even Mr. Shapiro was coming on. He had some connections with coaching, and that apparently was an attraction. That's certainly enough to give rise to a duty. Now, our argument for duty is that foreseeable, you come onto someone's premises, whether you enter a house, a courtroom, this is general duty of care. Now, obviously the analogy might be to all the criminal acts, but that gets down the road for summary judgment. We certainly have enough for legal duty. As to notice, again, as Justice Lemoyer pointed out, we allege credible results, credible reports, some knowledge. Yes, we don't have specifics. We don't specify that. And that's their problem. They say you need detailed accounts. Which were these reports? This is the pleading. We haven't even given a bill of particulars. And again, let them answer. We'll do a bill of particulars. We'll get a discovery, and that can be sorted out. This is what Justice McCrae was pointing out. And then the third point about consent. Well, first of all, I really don't. We argue that there's no need to allege consent, lack of consent in a CVA case or a sexual abuse to take advantage. And the reason for that is that the argument now for pleading lack of consent comes from Penal Law 130.05, which now says, as a general matter, the prosecution in a sex abuse case must plead lack and prove lack of consent.
And then there's some certain exceptions there. Their argument now is that, well, gee, that now constitutes under 130.05 is now brought into this by the CVA. Now, all the CVA says is that that for purposes now of determining what the sexual misconduct, they borrowed now from Article 130, the language constitutes a sexual offense under Rule 130. The conduct, the idea is that what did the defendant do? Now, pleading consent has to do with what the plaintiff did. And it just seems abhorrent now to the fact of the CVA that they now have to require this pleading. So,
Let me ask one question, Counselor. When we're dealing with the 1981, he was 16 years old, correct?
correct.
Okay, under the statute, there, he can't give consent.
I'm sorry.
Under the statute, he can't give consent.
That's true as well, Your Honor.
You know what I'm saying?
I overlooked that.
Yeah, so at the end of the day, I mean, you don't have consent on that.
Makes no difference at that point. Now, again, there may be, I think what we're trying to do at that point, we weren't sure what the years may have been.
Yeah, it only changes in 82.
Right, in that regard. But the fact is now, again, we have the consent that's pleaded. Again, not in the specifics that everyone want, that Syracuse want, but we submit, as Judge McRae said. And Judge McRae, I think at one point I have to agree with him. He said, hey, we have maybe minimally achieved now sufficient specificity for purposes of the notice. Let's get on now to discovery. So unless there are questions on that, I'll just simply rest on our brief on that point. But I would stress, though, that, and again, the segue into now Camp Greyhound is looking now at what the legislature meant when they basically defined sexual misconduct that now is going to invoke the CVA when they said now, we now are going to borrow. We're going to borrow now the language of what constitutes a sexual offense as specified in Article 130. Now, again, it's the conduct. Now, as to Camp Greyhound, and what Judge McRae did is, Judge McRae said that at least with respect to Mr. Shapiro, and again, he's the one now, only one who's at this point that we're really dealing with. Shapiro now, and again, we'll say with Camp Greyhound, all three now did allege abuse that occurred in Massachusetts. Now, Shapiro also had the abuse in Syracuse, not a problem. But now, what about now the abuse that occurred outside the state of New York? Judge McRae said the CVA does not cover sexual abuse that occurred outside the state of New York. Well, again, keep in mind here that when a court has an issue as to the statute of limitations, which is what the CVA is, they apply New York's statute of limitations, even if the conduct occurred outside the state of New York. This is a basic conflicts rule. So it's no real issue about extraterritoriality. What real issue is now, what did the legislature intend with respect to this reference now to 130? Now, if you look at 130, it's sexual offenses. There's nothing there specifying that the conduct must have occurred in the state. They're just talking about the conduct. Now, of course, the court knows that we can't prosecute for a crime that the DA can't prosecute something that occurred in Massachusetts, maybe a conspiracy or something, but straight out, the Onondaga County DA certainly couldn't have prosecuted this a crime. And as well, we know that and that's where does that come from? That comes from the criminal procedure law, 2020. That's a venue provision. It's a venue provision. And then if you really want to get technical, not just to be in the state of New York, it has to be in a county. We have our issues now with DA overlap. Which county should this be prosecuted in? I submit that the legislature did not want to get into that. And then, so on the language here is simply just look at the conduct, not where it occurred. If they wanted to say where it occurred, they would have said so. They may have put in a reference to CPL 2020. But then what's interesting then, you look then at the policy. The result now that Camp Greyhound is trying to achieve is you have at least two New Yorkers at the time they were abused, Mr. Shapiro and David Sweet. They were New Yorkers. We put allegations in the complaint that Camp Greylock at the time had its principal place of business in New York. Now, yes, they were a Massachusetts corporation, but their principal place of business, where they operated year-round, was in New York City. Now, during the summer, basically, operations shifted to the camp. You basically have here a New York corporation. Does the legislature really intend to prevent a New Yorker who's been abused by a New York defendant when it's out of state, has no remedy under the CVA? I doubt it. I really doubt it. And it's nothing in the legislative history that would suggest that. So what it really comes down to, lastly, and no, I'm getting close to my time, Your Honor.
You are.
So I just another minute.
Yeah, please.
Okay. If you then look at what the basic argument comes down to is the language then of 130. And again, I submit the language of 130 says nothing about the conduct where it occurred. And I'll borrow a phrase that Judge McCrae said in rejecting Syracuse's argument about consent, that the legislature borrowed the conduct from 130 for purposes of the toll, not the crime. Now, certainly the DA could not have prosecuted, New York prosecutor could not have prosecuted this. But it looks like, again, Judge McCrae, I think, got it right on that point. And the idea here is that you borrow the conduct. The legislature was lazy. And quite frankly, I think maybe a beast. If you look at the CVA has 3 references to sexual misconduct. First, offenses, conduct that would constitute a sexual offense under 130, or incest, as defined specifically in the statute, or performance of a child in a sexual way, is a specific statute. What they're dealing with now is simply the conduct. They're not looking at whether this was a prosecutable crime. So I think in that regard, again, it may be, again, typical maybe sloppiness of the legislature, dropping it all on your hands. But I think they did the best that they could. Now, lastly, I was
Mr. Hutter, you need to wrap up.
Okay, lastly, I say all the cases so far have rejected this argument. They're all Supreme Court cases, and it's a federal court case. This is the first court that is reaching this issue. I believe that there are pending, not yet for argument, but the issues are going to be raised to the first and second department at one point. But this is a case of first impression for the appellate courts in New York. Thank you for your patience.
Thank you, counsel.
Good afternoon, Your Honors. Lana Ivy, Harris Beach, and I want to be clear that I represent Camp Greylock, Inc., which is a Massachusetts corporation founded in 1995, so about 20 years after any of the allegations occurred. I do not, and as far as I know, no one has represented Camp Greylock for Boys, Inc., which pre-existed us and is not at all the same corporation. We ask that you affirm the dismissal of Camp Greylock, Inc. On several grounds, the main one being what the trial court decided warranted dismissal. The CVA, by its plain language, we can look at the intent, and we obviously went through the intent in our briefs, but the plain language says that it's triggered by criminal acts under New York penal law. And it lists specific sections that needed to be violated to trigger 214G. So it's actually a very straightforward analysis. I don't think you get to the borrowing statute. I don't think you get to any of that, because these events all happened in Massachusetts. That's undisputed. And I will note that 214G clearly talks not just about the type of conduct, it's talking about the statutory provisions, because it lists certain provisions and then it finishes with, or a predecessor statute that prohibited such conduct. So it's really only talking about violations of New York penal law. And those could not have occurred here from our perspective, because New York penal law doesn't cover events in Massachusetts. I want to briefly address this claim that for Camp Greylock Inc., New York is a principal place of business. That is, first of all, legally completely irrelevant. The statute certainly doesn't differentiate between New York defendants and non-New York defendants. But factually, it's just plainly wrong. And I went through their brief pretty carefully to see what evidence it is that they point to. Because the camp, the only thing this corporation does is run a camp in Massachusetts. There are no operations or anything else in New York. There is an 800-foot office that is used for a couple of months in the winter, and that's about it. The only evidence I saw
Where is
cited,
that?
yeah,
Where is that 800 square foot?
it's in New York City. So the only evidence that they cite that's in the record, and it's page 494, but this is what it looks like. And frankly, it's attached to an attorney information. I don't know what that is. It's from a yearbook. But if you look at it, it's a picture of what looks like a park with some stones. It says Beckett, Massachusetts, and it's from 1974. So there is a New York City address on the bottom. I understand, from what I understand, it's the home office of the camp director in 1974, but it really has no relevance to the principal place of business of that corporation, and certainly not to my client's principal place of business. And I think, you know, they're basically arguing for expanding the CBA. So you have to look at public policy. And if you're going to argue for expanding it, this is not the case. My client did not exist until 20 years after this happened. My client did not hire, train, supervise anyone who was involved. The asset purchase agreement in 6 different places says that my client was not assuming any liabilities for operations prior to 1995. It is there over and over and over. And we also have in the record an affidavit from an insurance expert that says, you know, for any organization, whether it's a daycare camp, they can't get insurance for that type of thing. You can't get insurance to cover conduct 20 years before you existed. That does not exist. You know, did they have a claim against Camp Greylock for Boys Inc.? I don't know, but, and did that organization have insurance? Maybe, but that's not us, and the court was right to find that.
I
And we
think
asked
we
that
have
you.
that argument, counsel.
Thank you.
Thank you.